Okay.
And I think that goes, so. I've opened the record now in the matter of Twig v. Ball, case number 2015-2249D, 2249. My name is Marc Crotteau. I'm a referee with the 37th Circuit Court. Because this matter is being heard by a referee, any party has the right to file an objection, asking the judge to review any findings or recommendations that come out of today's hearing. Anyone choosing to do that has to do it within 21 days and in accordance with Michigan court rules. Present for today's hearing by way of Zoom is Brianna Twig. Is that correct, ma'am?
Yes.
Not present for today's hearing is Donovan Ball. I will note that Ms. Twig filed a certificate of mailing indicating that she did in fact send notice of today along with the motion to Mr. Ball at his last known address. Let me just confirm, ma'am, is that correct?
Yes, sir, that is correct.
All right. Then under the circumstances, I find that he had proper notice of today's hearing and has waived his opportunity to be heard today by failing to appear. Ma'am, the thing that I need to do today is to determine whether there has been a change in circumstances or proper cause since the current order entered that would allow the court to think about changing the orders. Essentially, what's different now than was when the current order entered? And I see it looks like the current order is from October of 2019. So what is different now than was then?
Well, the boys have been in the home with me. We moved into a 3-bedroom on August of 2019. And after we moved, the boys moved in with me, and the dad was sentenced to 7 months in jail. So we went to court. I filed a motion and we went to court, and then I was given the temporary, the physical, and the custody of the children. And Donovan Ball got out of jail 7 months later, and he was working. So the front of the court seen that in the system, and they were to order Donovan to pay me $500 a month in child support. He was working at Target Distribution, and he appealed that. And when he appealed that, he never informed me through via mail the hearing. So he went to a hearing on December 1st, and he reported that the boys had been with him 365 days of the year out of 2020, and they were with me 0 nights. So it allowed me to take child support out of my unemployment, and I'm raising 4 kids, which are Donovan and Davion Ball, and my other 2 little ones. We have Section 8 based income living. They've been on the housing, and I do receive housing. I do receive food stamps for the kids, but that's why I'm here today, so I don't have to pay child support. And he can have the kids every other weekend, but they need to be in school. And right now he's not stable, and they have to be on Wi-Fi on their computers Monday through Friday.
Okay, let me clarify a couple of points. You said that when Mr. Ball showed up in December to court and said that the kids were with him 24/7, that was in fact not the case?
No, sir. He had in fact been in jail from like June till August of 2020, and he got the boys a week before Thanksgiving for visiting, and he had just didn't give them back until I recently got them back a month ago.
And as a practical matter, they're staying with you all the time?
Yes, because we have a home, and he's staying with family and hotels. So I just think that's best for the boys. They're 12 and 11, and they need some stability so they can finish high school.
Okay, so not only are the kids staying with you, but your testimony, the information you're giving me today is that Mr. Ball's housing situation is unstable right now?
Yes, sir.
Okay. Well, under those circumstances, I do find that there is a change in circumstances or proper cause. I'll note that the current order from a custody and parenting time standpoint gives joint legal custody and primary physical custody to you with parenting time as you and Mr. Ball mutually agree. So that part, nothing needs to change as far as that part goes, based on what you told me. However, it is clear that from what you told me that child support needs to be addressed. So what I'm going to do is I will set this matter for an evidentiary hearing in front of me as it regards child support issue. And that'll probably be in 3 to 5 weeks, depending on what the schedule is. I don't know for sure, but
Yes, sir.
whatever the order is that comes out of that hearing, it can have effect from the date that you gave notice to Mr. Ball of these proceedings, which looks like would have been January 6th. So the new order could potentially have effect from January 6th.
Yes, sir.
Any questions about that?
No, sir.
Any other issues that we need to address today?
No, just I just feel like the kids are more well off with me because they're kids, and they don't want to go to school and they want to play the video game, and as a parent, I don't feel like that's okay. We have to be more strict on these kids or they're not going to make it. And they're, like I said, they're going to be teenagers and I don't want them to be disrespectful or ending up in jail or, I'm just trying to be the best mom I can be.
Okay. So what will happen is my staff will send you notice in the mail at the address you confirmed for me before we went on the record of a next hearing date. Show up for that date and we will address what the child support order should be. If Mr. Ball appears, that'll be great. If he doesn't, then we'll see. I guess there are options if he doesn't appear, but hopefully he'll show up and we can address that. Any other questions right now, ma'am?
No, thank you.
All right. I will remind you that you have 21 days to file an objection if you want the judge to review my decision.